someone I know was summoned to appear in a district court, ostensibly to testify as a witness to a crime they saw being committed. A detective came to take a statement, but didn't provide a copy of that to the witness, which is a bit odd considering that they would most likely be subjected to cross-examination by a defence lawyer, and could hardly be expected to remember every word for recall many months, even possibly years later. Despite a copy being repeatedly requested, it has still not been provided. Another disconcerting element concerns the fact that the alleged offender was observed leaving the scene by the witness, who was known to the suspect and lived close by. The case involved major damage to property used by a relative of the accused, which, although not proof of, is still a possible indicator of mental health issues, since most people don't set about destroying the property of family members. Despite repeated requests for steps to be taken to minimise the chance of revenge action being perpetrated against witnesses, these have been consistently ignored. The summons notice did not qualify as a lawful instrument for a few reasons. At the bottom, where the details of service are supposed to be recorded, all spaces are blank, as shown here. Thus, no one is taking responsibility for issuing this unlawful command, as is required by law. Above the blank spaces, we see the court seal. This is not the crown seal, which bears the well-known lion and unicorn symbols, though it is perhaps very appropriate to note that this seal displays not one, but two kangaroos, presumably to leave no doubt in the minds of the recipient what type of court it is to which they are summoned. The specific case details ought not be shown for obvious reasons, but the sections labelled Command and Warning warrant some comment. Since all subjects of the Crown are equal before the law, no one has automatic authority to command anyone else to do anything. Authority is not automatic, it must be granted, and for that to happen, there must be a binding agreement between the parties, based upon a commonly held code of morality, embodied in an oath of service under constitutional law. That law, in the case of the British Constitution, must in turn be upheld by the monarch. Or, if that person is failing in upholding that contract made with the subjects via their coronation oath, by the Committee of Barons, acting under Article 61 of Magna Carta, if that article has been invoked. Even in the extreme case that neither the monarch nor the barons are upholding the Constitution, the individual subjects still have the inalienable right to lawfully dissent from any person or group claiming to represent the Crown, but unable to present irrefutable evidence that they do so. The absence of any properly constituted lawful authority in no way permits any persons or groups to set themselves up claiming to be, quote, the government. If one group be permitted to do so, then the same privilege must exist also for any other persons or groups to make the claim. In that situation, we would be in a completely lawless community, which was to be ruled by brute force and dominated by the most ruthless administrators of violence. We see this type of society in various locations around the world, do we not? In fact, however, each person is their own sovereign, with personal autonomy which cannot properly be granted or denied by any other person, since under natural law we are all endowed with the same rights of liberty and sustenance of our own lives. Again, it must be stressed, anyone claiming authority to command others must be able to demonstrate from whence that authority stems. And this is where our legal system is exposed for the morally bankrupt contraption it has become. When agents claiming to represent the Crown are challenged to prove that Article 61 was not invoked or is no longer in effect, they are completely powerless to rebut that statement of effect in law. Now to the warning. Exactly the same principles are in operation here. Without verifiable lawful authority, this statement, quote, "If you do not obey this summons, you may be arrested, and also you may be imprisoned or fined or both," end quote, consists of an assault and a threat with menaces. If carried out, those committing the crimes could be charged with assault, kidnap, false imprisonment, and any other torts involving trespass, theft, if property or money were confiscated, conversion and detinue, just for starters. It is important to recall here that under Article 39 of Magna Carta, no person may be arrested, imprisoned, deceased, i.e. have property taken, or outlawed or exiled, or in any way destroyed, nor gone against, nor had anyone sent against themselves, save by the lawful judgment of their peers or by the law of the land, end quote. This article, when we examine it more closely, clearly prohibits the state from initiating any prosecution against anyone. That option is available only to an individual who has been wronged according to the law and wishes to bring the alleged offender to trial before a jury, after which the Crown should execute whatever penalty has been lawfully decreed by the jury. The state's only role is to facilitate the trial, which, according to Article 40 of Magna Carta, shall be without cost to the plaintiff, paid for from state revenue. All options as to what shall be admitted as evidence, the guilt or innocence of the accused, the justness or otherwise of the statute which brought the defendant to court, the sentence, and any costs or damages awarded, including those incurred for cases of vexatious litigation, are the province of the jury, not the state. Nowhere in the Constitution is the state given the prerogative of initiating prosecutions. These are purely between individuals, that is, living beings. The state is not a living being and cannot therefore initiate actions against living beings. By this means, people consent to be governed according to universally held codes of morality by their peers, the people amongst whom they spend their daily lives. The people are the final arbiters. The government merely enforces compliance with the will of the people as expressed via the jury. It has no other legitimate function. Its role, as Spinoza said, is merely to ensure that all live in liberty and free from fear of depredation by criminal elements. Clearly, people claiming a government authority and attempting to enforce arbitrary edicts without such lawful authority belong in the class of criminal elements, just as much as petty criminals committing their crimes. The latter at least have the honesty to admit that they are pursuing selfish personal motives. In the case we're discussing, the court and the Office of the Director of Public Prosecutions were put on notice of the unlawful nature of their demands, together with being presented with evidence of their operations as for-profit corporations rather than legitimate agencies of the Crown. They were invited to rebut these pieces of evidence, which, if done, would ensure compliance with their demands. However, to date, the only communication has been a telephone message that the trial specified for the date shown on the summons has been cancelled. No indication as to why was offered, leaving the summoned party and their supporters to speculate as to the reason. Would they have even been notified without sending in the notices? Or would they just have been allowed to make the journey to the court, if unaware of their rights, only to be told, "Oh yes, that trial's been postponed. Sorry for the inconvenience. Didn't anyone tell you?" Was it because the case had collapsed, perhaps on a technicality? Inadequate paperwork, as evidenced here, frequently causes such dismissals. Or was it because the department and the court had decided that the notices and the request for rebuttals made, in the opinion of said entities, the summoned witness too much of a problem, best left out of the courtroom, and thus unable to raise awkward questions? Or was it because the fake authorities had calculated that as a for-profit corporation, the amount of revenue that could be raised from the defendant made the case non-viable? Another friend of mine once witnessed an elderly gentleman being attacked in the street outside my friend's home with a sword, which clearly resulted in grievous bodily harm. Despite spending his time and money providing evidence to the departments under discussion here, that case never went to trial, despite the accused being apprehended and possessing a lengthy record for violent assaults. Was that because the defendant was of indigent means and unable to pay a heavy fine, whereas imprisonment would have been a cost to the corporations running our justice system for a profit? One suspects it's unlikely that an FOI request would reveal the truth. One could be forgiven for thinking that running a justice system for profit, rather than on the moral principles underpinning our Constitution, is open to all manner of abuse and is a woefully inferior modus operandi. In fact, a call to the District Court revealed that the case we began discussing here has been deferred to another hearing date, a month or so hence. The issue thus remains a live one, and the remaining notices will be sent, together with a number of supporting letters informing the court and the ODPP that there are others who are aware of the criminal activity of their kangaroo court system and the growing size of the files which will ultimately be produced before a jury with multiple witnesses and irrefutable evidence for them to answer. The bottom line is that there is simply no lawful action that these impostors can take to enforce compliance. Whatever actions they may decide to threaten or undertake will be liable to counterclaims for substantial damages, even criminal charges. The courts know of the law and Article 61 and cannot afford to openly commit treason. As in the case of Danielle Davidson, the final chapter in The Emperor Wears No Clothes, Article 61 is enough to stop even judges and courts in their tracks. It's a time for tight sphincters. Thank you for watching.